Hello and welcome to episode 72 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh LaHaws, counsel with the Canadian Constitution Foundation.
I'm Joanna Barron, Executive Director of the CCF.
And I'm Christine Van Geyn, the CCF's Litigation Director.
In today's episode, I'll discuss the Supreme Court's recent decision to grant leave to a case that engages some pretty fundamental questions about the notwithstanding clause.
And I'll tell you about the highs and lows of our appeal in a legal challenge to British Columbia's discriminatory vaccine passport program. And I'm sad to say it's mostly lows.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about a bunch of recent incidents that have people calling for hate speech charges and why I think they're unlikely to happen in most cases. So I want to preface this by saying that I think at least some of these people, most of these people are, engaging in really disgusting behavior, and I don't condone that whatsoever. And so I get why people are upset, and I get why people are asking police to investigate. But we can't lose sight of the importance of freedom of expression here. And we have to remember how dangerous it can be to give the state the power to decide what we can and can't say. Just because we don't like speech doesn't mean people shouldn't be allowed to say it. If police can, shut down speech that we don't like, they can also shut down our own speech when we have something to say. So the first incident I want to talk about is this group of three masked losers in St. Albert, Alberta, who are standing outside of a shopping mall flashing signs that said things like "Deport them all" and "White Lives Matter," and most egregiously giving Nazi salutes to people driving by. And this actually echoed a similar incident where a slightly larger group of men were doing this sort of thing in Hamilton, Ontario. And they had a sign that said "Mass deportations now." And not too long ago, we saw this woman in Montreal. We haven't talked about this yet on the podcast, I don't think. This former Second Cup franchisee who is actually facing charges of criminal incitement to hatred after she could be seen on video talking about the final solution and giving Nazi salutes. And she was doing this to a crowd of people with Israeli flags and presumably Jewish people in the crowd. And finally, just this week, there were some claims that men were engaging in hate speech by silently holding up a banner at a Dufferin-Peel Catholic School Board meeting where trustees were discussing whether or not to allow pride flags, a hot issue right now. And their banner said, "Hands off our kids." So I'm going to walk through the law and explain why I don't think these incidents, with the exception of the Montreal one, are likely to warrant hate speech charges under our law. And like I mentioned, the starting point is the charter and that you have freedom of expression. And that means you can say whatever you like, regardless of the content of that speech. And that includes even the most vile speech. Even the Nazi salute would be covered under Section 2B of the Charter. But the Supreme Court has said, and you can read more about this in Christine and my book, Free Speech in Canada, that it's okay to limit free speech when it rises to such an extreme level that it's inciting others to discriminate or hate a protected group. And as a result, they've upheld criminal hate speech laws. So there are four specific criminal charges in Canada that relate to hate. They're advocating genocide, public incitement of hatred, willful promotion of hatred, and finally the new law against willful promotion of anti-Semitism, which means condoning, denying, or downplaying the Holocaust. And these don't get charged much, and there's a few reasons why. First, almost anything, unlike almost anything else in the criminal code, prosecutors have to go to the attorney general before they can lay these charges. So that prevents a lot of, not very likely to succeed charges from going forward. And then the other thing, and we've talked about this a bit before on the podcast, it's just really hard to define hatred, a notoriously subjective concept. And the debate about whether from the river to the sea is a call for genocide, and therefore hate speech really shows how subjective this can be and how people can have very different views on what counts as hatred. So the Supreme Court said in Walcott in 2014, or maybe 2015, that this was a case about, whether this man had been discriminated against or had discriminated against people by handing out anti-gay pamphlets, that hatred is restricted to those extreme manifestations of the emotion described by the words detestation and vilification. And that doesn't include speech that merely ridicules, belittles, or otherwise affronts the dignity of a person or a class of persons. And then they gave these examples of what might count as detestation and vilification that could warrant criminal charges, including alleging a group is a powerful menace, alleging a group is plotting to destroy Western civilization, trying to delegitimize a targeted group, suggesting that members of a group are illegal or unlawful. And then we got Ward in Quebec, and the court there clarified a bit more. They said limits on free expression are only justified where, in a given context, there are serious reasons to fear sufficiently specific harm that cannot be prevented by the discernment and critical judgment of the audience. And that harm is, again, inciting things like discrimination or inciting hatred. In other words, egging other people on and not just expressing a hateful opinion yourself. So let's look at this speech. Okay, so the hands off our kids message, clearly this is not even close to hate speech. This can mean a lot of things. Hands off can mean basically, I don't want you to teach my kid this particular theory about gender. There's no targeted group here. There's no powerful menace alleged. There's no attempt to delegitimize the entire group. So that's just not going to be hate speech. If we look at the White Lives Matter message, a lot of people consider that racist, but again, there's no group targeted here. It's just talking about, Caucasian people, presumably. And then we get into the things like deportation. Like that alone is mass deportation. That's not going to be hate speech. But if you were to say something hypothetically like deport all Swiss people because they're subhuman, sorry, Swiss people, I love you. That's just like a hypothetical. I think that would get a lot closer to the criminal hate speech line. But we still have to ask whether, it counts as that extreme form of detestation or vilification. The interesting one is the Nazi salute in Montreal. That gets a lot closer to the line, like I said, because of the context, because it's in a group of people where there are, probably visibly Jewish people there. We definitely saw Israeli flags. She's not just doing a salute. She's also talking about the final solution, really chilling, horrifying stuff. And you could make an argument that perhaps she is inciting and whipping up the crowd, but the Crown will have to prove that she intended to do this, and that's tough. So we'll see what happens here. Joanna, I was on a radio show talking about this stuff yesterday, and the question they were asking is like, okay, if you can't get charges against these people in Edmonton, what should we do? Should we just ignore it and not amplify it? What do you tell people when you get asked this question?
Name and shame them. So in the case of the woman in Montreal, who, by the way, I saw some of the pro-Hamas, pro-Palestine accounts on Twitter saying this was a Zionist plant. This was actually a pro-Israel person. And then it turned out to very much not be that. But what I thought was impressive was her, and you may have mentioned this, her franchise agreement with the Second Cup at Montreal Jewish General Hospital was immediately canceled. Like on
Wait,
the
it was the Jewish hospital?
Yeah, Jewish General Hospital, which is just like it's like the major hospital in downtown Montreal. It's open to non-Jews, but it is the Jewish General Hospital. Yes. So
the reason was that Jews were not allowed to practice medicine in other hospitals in Montreal, so they had their own hospital. It arose because of anti-Semitism,
right? And
then the Second Cup franchisee working in that hospital is an anti-Semite. It's so ridiculous.
Yeah. Anyways, yeah, it's like the preeminent, it's on Pine Street, just down the street from the law school. I may or may not have visited the ER room during, stressful periods of law school. So I've been there many times. But kudos to Second Cup. The CEO, I think, left a movie in the middle of a Sunday afternoon when he heard of this and was like, you're done. And that's completely appropriate. A private business like Second Cup has no obligation to continue working with an individual who has abhorrent values. So you can do that. You can fire them. You can name and shame them. You can track them to see if they're actually materially supporting terrorism. There are lots of things you can do. I don't know, Christine, if you want to talk about our mutual friend and their interaction on Facebook Messenger this week, or if I could
Oh my gosh, yeah.
that is chilling because she'll tell the story, but basically it only took a little bit for this person to say, I stand with Hamas and the resistance anywhere in the world. I specifically remember that line, anywhere in the world, just in an interaction over like buying a baby seat or something.
Yeah. So my friend, this is like not super related to the topic, but I'll tell it anyway.
It's an example of things that when people say abhorrent things, ways that you can deal with them while remaining, true to our civil libertarian principles.
Yeah. So my friend was trying to sell like a used baby swing, which is basically what you use Facebook for these days. It's the only purpose left for me to use it,
get
to
rid of
junk in my house. So she had listed like, I don't know, it was like $50. She's selling this expensive baby swing, and someone writes to her trying to haggle her down in price and wants to, I mean, these are all my grievances with Facebook Marketplace, aside from the anti-Semitism that comes next. First, he's trying to haggle the price. Then he says, can I come and look at the swing? I would just say no, like you are either going to buy it or you're not going to buy it. Don't come to my house and waste my time. So then he's like, can I come and look at it? Send me your address. So my friend, being, a savvy lady, looks at his profile before agreeing to let this stranger come and look at her swing in her house. And she sees a few things on his profile that are disturbing to her. And she and her family are not Jewish, but they are, pro hostage. They are concerned about the hostages in Israel. And she said, look, I looked at your profile and I'm not comfortable giving you my address because the things that you post on Facebook look pretty extreme and look like you actually support Hamas. And we in our household support the hostages and we're very worried about this. And he replied saying, I absolutely support Hamas and I stand with the resistance anywhere in the world. And she said something like, if you support Hamas, go to fight with them then, like, please get out of this country, go there and go and do that. Like, I don't want you in our country supporting Hamas. And he said, that's a racist and I'm a professor, which then got into a whole back and forth that I would not have done.
A professor where?
I think it was very racism of you.
Oh yeah,
that's a racism.
That's a racism. So anyway, that's the story.
No, but anyways, the point is that it turns out that he's a prof or TA at Ryerson. Yeah. And so now there's like a kind of letter writing campaign to Toronto Metropolitan University to alert them that this is the type of person that you're employing and paying. And knowing TMU, they may be excited by this.
Yeah,
that's a cancellation I can get on board with.
The thing that's crazy is, so she found him on LinkedIn and he has pronouns in his bio. Like, Hamas does not like that. Hamas does not stand with pronouns in bio.
To be fair, just because someone openly supports Hamas doesn't mean that you should expect them to openly support Hamas just because they do.
Yeah.
That's a racism.
That's a racism.
So anyways, you can get them fired from their job, but no, I don't think in this case sending the police to Mr. He, him, I support Hamas would be appropriate.
I actually would think that having CSIS investigate people who say they support Hamas is totally reasonable, because if you are financially supporting a terrorist organization, you should be in jail.
I don't think he's financially supporting Hamas.
We don't know what he means by
he's haggling over the baby swing, but maybe that's so he has more money.
So he has more money to send Hamas, maybe. Like, who knows what his motivations are? Anyway, I was really riled up about this. You know what disturbs me is like I don't know how much of this exists below the surface, and I think there's a lot of naivete
Yeah.
among people that it's just about the children of Gaza, who we all are concerned about the children of Gaza, but how many people say it's about the children of Gaza but actually also support Hamas? Like I am concerned about children, but I don't support Hamas. And I'm really worried about how much of that is actually out there. And I think there's a lot more of it. I think there's a lot more of these Ryerson guys than we expect. And we're very naive about it in this country. Anyway, I'm going to move to my news headline now.
Speaking of getting riled up.
Yeah, I got riled up fast.
Yeah.
I'm like,
No, but now
like,
you're really going to get riled up.
We're all riled up this day.
I'm already at a 10. I'm about to go to a 12. So my news headline, my update today is about our decision in our BC vaccine litigation. So you might remember this case. This is a case we argued back in October of 2023, so quite a long time ago. If you've forgotten about it, I forgive you, because the court took a really long time to get us a really short and kind of pointless decision. The case is called Kassian and British Columbia. It's an appeal, BC Court of Appeal. And it was an appeal of a charter challenge that we had brought with 3 women to the British Columbia vaccine passport scheme because the scheme didn't have workable medical exemptions. So it had us, the CCF, as a public interest litigant, and it had 3 women, a woman named Sharon, Veronica, and Erica. And Sharon had developed a rare reaction to the first dose of the COVID vaccine. She had the Pfizer vaccine. She got a neurological condition called brachial neuritis. Erica was a teenage girl. She developed a more common adverse reaction that's more common in pediatric patients. It's a type of heart inflammation called pericarditis. And then Veronica is a medically complex person. She has spina bifida and hydrocephalus, and she also has had about 15 surgeries in her life. She's had many bad outcomes and many adverse drug reactions. And she, because of her own knowledge about her reactions to all kinds of things, said, I'm not going to get vaccinated because of this. But Veronica uses the pool for swim therapy to manage her disability and wasn't able to use the pool because she wasn't vaccinated. So the appeal we brought, I'll start out of the gate, it was unsuccessful. I'm actually pretty devastated about it, and I'm really, really devastated on behalf of these women. This was so important for them. There were some bright spots in the decision. There were some things that we can sort of celebrate, but there was a lot of really bad things. So let me first say, I think that the court was pretty fair in their description of these 3 women, Sharon, Veronica, and Erica. It described them with compassion and with empathy. It was also accurate in the description of us as a public interest litigant. You know, sometimes when we talked about this litigation, the media would say, you know, we're an anti-vaccine group. We're not an anti-vaccine group. This court decision correctly characterized us. I think anti-vaccine is often used as an ad hominem to just attack any person or organization that has like the not like public health COVID response, like talking point on vaccination. So anyone who had any different perspective was called anti-vaccine. And the court didn't do that in this case. It sort of correctly said that we did say that COVID was a serious illness, but that individuals should not be subject to government pressure to get vaccinated, and people should be left to make their own decisions without the specter of state sanction. And so for once, I think that this was quite a fair characterization of us. So I think that that's good. I also think that that is different because at the height of the pandemic, people were not being described fairly at all. So I'm really happy that there is now a broader understanding about the needs of, you know, people with disabilities, medically complex people, and we can, that more people are now actually talking about them with compassion instead of condemnation. So I also think that the court did understand our arguments about the problems with the BC vaccine passport regime. I think the lower court didn't quite understand our how we were explaining this, and it was really complicated, that system. And the court here in the appeal did acknowledge how it was complicated, that it was in constant flux. It changed many, many times with rules that would fluctuate between how rigid they would be. You know, at first the regime included very limited exemptions. Then they stopped taking exemption requests at all. Then they created a medical deferral that could only be completed by a form that could only be completed by a doctor, that had this list, a checkbox list with just a few acceptable reasons for an exemption with no write-in category. And the court described all of that and understood it better than the lower court did. So that was all good. Now, onto the bad stuff. I think that the court understood the serious problems with the regime, but they unfortunately granted undue deference to the BC public health officer's interpretation of that regime. The BC public health officer had interpreted the orders as not having a closed list of conditions available for exemption. So there were only these few conditions, and you know, Sharon had a rare condition. Veronica didn't have one of these conditions, and they were not eligible to have one of these tick boxes checked off. Said that the public health officer was taking, you know, you could just write in the margins, you had something different, and that that's how they interpreted it, and that interpretation was reasonable. Even though it contradicted the text of the orders, and even though the patients who we worked with concluded, we think reasonably, that they were not eligible for an exemption, the BC court said that the public health officer's interpretation is a reasonable one, and so it gets deference. I don't agree. I don't think it was reasonable. I don't think it should get deference. So on that basis, because of what they said, the public health officer's interpretation is, they said that the claims of Aaron and Veronica should be dismissed as premature because they should have gone to the public health officer, who would have maybe given them an exemption. They should have tried. There was a little bit of good news about Erica, though. That's the teenage girl who had pericarditis. So the court actually said that it was arguable that for a period of time, there was no way for Erica to obtain a blanket exemption. Between November 12th, 2021 and December 21st, 2021, so for a month and a half or so, the public health orders were on an exemptions were on an activity by activity basis. So you would have to say, I want to go to the movies this week, consider my application. I want to go see my grandma this week, consider my application. I want to go to a restaurant, consider my application. You'd have to send it in every single time. And there were no blanket exemptions. For that period, the court held that the process created by the BC Provincial Health Officer was unreasonable, that the rationale for denying blanket exemptions was never apparent, and that this supports the view that the orders were more restrictive than necessary. So Erica, even though she was eligible, she was in one of those tick boxes, she could have applied for that period. She would have had to apply like anytime she wanted to leave the house. So they said that was unreasonable. And they wrote that on the face of it, there would appear to be some force to the argument that the regime that unnecessarily restricted exemptions to individual activities or series of activities served to further disadvantage persons suffering from medical conditions contraindicating vaccination. So people with disabilities like Erica. But, so that's good. That means that we're supposed to now get to the charter analysis because the decision was unreasonable. But the court declined to do the charter analysis because they found that it would just result in a declaration of her rights that would have no practical consequence. Like, I don't even know why they took the case, because they did a whole hearing on mootness and said, we're going to take the case even though it's moot. And then they decide, well, it's moot, so we're not going to issue a declaration. Like, it just doesn't make any sense. And I have a lot more to say on moot declarations and whether or not courts are willing to grant them in much more extreme circumstances than this one, which is a more controversial topic. But that's for another episode, or maybe for Joanna's headline, I think. So I think that if they had done a charter analysis based on what they said there, right? On the face, there's force in the argument that the regime restricted restricted activities that furthered disadvantage. That's all the language of Section 15 of the Charter. So I think that if they had gone on to do a charter analysis, in my view, they would have found that Erica's charter right to be free from discrimination was unjustifiably violated. Like, I don't know what at least that it was violated. I don't know what they'd have found on Section 1. Maybe they'd have found that it was justified, but I don't think they would have. It's really, really sad that they declined to do this analysis, and they said there would be no practical impact of a declaration, because this is a young woman. She was a teenager when this started, and she was experiencing a new and frightening disability after spending her teenage years in this pandemic isolation. So I think she really would have benefited from a declaration. Another silver lining of the case is that the court did find that there is no public interest in vaccinating people who are medically contraindicated. And that seems like it should be common sense, but you would be blown away by the number of people who said stuff like that during the pandemic. It was shocking. So, like, a few little things to hold on to here, but mostly this was disappointing for kind of technical reasons. The technical reason being this, exercise of judicial restraint for once in order to not issue a declaration for Erica. And then this absurd finding that the plain text of the orders can be interpreted to mean something entirely different by the public health officer, and then that interpretation is reasonable. So that's the case. You can go and read it. It's called Kassian and British Columbia, and I'm going to have an update on YouTube about it as well. Joanna, anything you want to say about this? I know maybe we'll start with Josh, actually, because you might be able to segue this into your news headline, which I know is about sort of the moot declaration issue more broadly.
Yeah, I'll start. Happy to start. So, I agree with all of what you said. And there are a bunch of silver linings in here, even though it's not a win. But there are also some things that are just really annoying me that you didn't mention here. Well, maybe you did actually mention this part. So, one of the reasons why the court says that they're not going to consider doing granting the declaration, they're not going to go into all the charter analysis, is because, to quote the court, to the extent that those restrictions existed, they were never enforced, and they lasted for, at most, a period of 3 months, and arguably for a much shorter period of time. And that's talking about the blanket declaration. So apparently, so if you looked at the forums, you would have thought every time I have to go to a birthday party, to swim in a pool, to see my friends, to see my partner, and we're talking about a teenager in the case of, I think it was Erica, right? The teenager. Yeah. So that's what the forums are saying. But if you'd actually applied, according to the court, they would have given you a blanket exemption. You just didn't know that because it's not on the form, and they didn't say that publicly. And then the judge is saying, well, that was only for a period of 3 months, possibly more. When you're a teenager, 3 months not seeing, your boyfriend, your girlfriend, your friends, it's an eternity. And so just because it's only a few months doesn't mean that the charter rights here don't matter. So that really bothers me about this decision. And then the other thing that jumps out at me that's just annoying me is it says, given the orders were frequently modified and that it's unlikely this precise scenario will ever be repeated, I would exercise discretion against entertaining the request for a declaration. What makes the justice so certain that this precise scenario wouldn't be repeated? I feel like it would be, but as you point out, there's lots in here that would, give governments pause before they do this exact type of thing again. So that is the silver lining. And one thing that I'm still thinking about is I wonder why this took 18 months. Like, this is an unusually long period of time to wait for a decision. And I guess we'll never know why it took so long. Joanna, what do you think?
I just think this is an affront to the whole idea of the rule of law. All of this stuff about the published rules as were understood by the petitioners as well as their doctors somehow don't matter because we know that because apparently the evidence is that BC public health officer was interpreting them in a way that had no support on, like, that's just not how the rule of law works. And it doesn't in other contexts. So this is a complete mystery to me where things went off the rails here. And also, it's kind of trite law that if somebody is harmed by the charter, I think McLaughlin said if one Canadian is harmed by a government law or action, it's relevant for the charter. So this whole thing about, well, it was just a few months, like, yes, it's especially rough if you're a teenager, but also, like, that's not a relevant consideration for charter applicability at all. So there's just, our lawyer called it a double ducking out, and it certainly is, and it sucks. So let's take a break, and when we come back, we'll talk about the new Supreme Court case that everybody's talking about. By everyone, I mean all of my friends who are nerds. Okay. Okay, so we got news late last week after we recorded last week that the Supreme Court elected to grant leave to a case that is known commonly as HAC. It's also called English Montreal School Board, et al. Versus Quebec. And the case is very important because it addresses the question, and we've talked about some of these issues before on the podcast, just a heads up. But now that it's heading to the Supreme Court, it has new valence. And the question is, does the notwithstanding clause, section 33 of the charter, does it effectively shut down any judicial consideration or conversation or ruling on a given law's constitutionality? Or once a legislature or lawmaker invokes notwithstanding clause, do judges need to basically shut up and sit back from their desks? So just to recap, section 33 of the charter states that Parliament or a provincial legislature can declare that an act shall operate notwithstanding a provision in section 2 or section 7 to 15 of the charter. And this means that for up to 5 years, unless the declaration is renewed, legislatures can shield laws from being struck down by courts on the basis that they would otherwise violate those sections of the charter. And this covers everything from free speech up to cruel and unusual punishment. But there's still apparently an open question about whether once the legislature invokes Section 33, judges need to butt out immediately, or whether they can opine onto a law's constitutionality, even though it wouldn't have any practical effect. And this is not a straightforward question. We've discussed I think Josh went through the arguments on both sides extensively in a previous podcast, but I'll just re-up them briefly. And basically, there's smart people who disagree on this issue. So it's a tough issue. And before I get into that, just to bring up the factual context that this is arising in, because actually I'm going to say in my op-ed, which is going to run in the Hub on Friday, that I think the polarizing context is going to matter here. So first, in HAC, in the Quebec case, it is a challenge to Bill 21, which is the Quebec law that bans ostentatious religious symbols like kiput, skull caps, hijabs on public sector workers. And in that case, in Quebec, the judge declined to issue any declaration because he said that he would be doing indirectly what he couldn't do directly. And there's a case called Ford versus Quebec that proponents of this view say answers this question entirely. And then the other case where a different judge came to a different conclusion was in Saskatchewan, where a group challenged Premier Scott Moe's preferred pronouns policy for school children. And there, Justice Megaw of the court suggested that in an injunction decision that he was open to issuing a declaration that rights were breached, even if the law was upheld because Section 33 had been invoked. And the Saskatchewan government fought this vigorously and brought up a case called Horner. The judge in Saskatchewan said that was obiter, so it didn't answer the question. Okay. So now, who are on the side of that judges can opine, even if they admittedly must uphold the law? So Robert Leckie, who was dean for quite a few years, maybe over a decade at McGill Law, and was one of my professors, and was just announced that he was appointed to the Quebec Superior Court, which seems pertinent given this potential judicial showdown that is happening. He's almost certainly going to become an appellate judge in the next few years, just goes with the background, McGill Law Dean, etc. So Leckie, other scholars, Eric Mendelson, Gregoire Weber say, yes, judges can opine. And they say, well, Section 33 is limited in declarations to 5 years. And this is also the period guaranteed by the charter for maximum period of time between elections. And they cite this as textual evidence that voters are meant to have a say and should have an informed say in whether lawmakers who invoke Section 33 were justified in doing so. And so having public judicial decisions can be influential and can help to inform the public about whether they want to vote again for a government that brought in a specific policy, notwithstanding charter rights. And the judge in Saskatchewan agreed with that. Now, at the other end of the spectrum are scholars like Jeff Sigalet, who's a professor at UBC Okanagan, and his position is that Section 33 serves as a complete prophylactic for the shortcomings of an overly judicialized rights discourse. So basically, judges having too much of a monopoly over rights. And as such, Section 33's purpose is to allow legislatures to also have a say over what the content of rights is. And he cites the subjunctive mood of Section 33 to bolster his point, which says that the law in question shall have operation as it would have but for the provision of this charter. And so to Jeff, this means that Section 33 creates a sort of parallel counterfactual world created by Section 33, where it's as if the charter does not interact with the impugned law at all. And so courts, therefore, must treat a law once the legislature has shielded it with Section 33, as though Sections 2 and 5 through 12 of the Charter don't exist, and they have to just shut up entirely. And so I think that there's so many things that are at stake in this case. We're very excited to see it develop, see who ends up intervening, etc. But I think given the underlying politics in Saskatchewan and Quebec, and how kind of at odds they are, this could actually be a really good opportunity for the court to pull away from ends-driven reasoning, which I think all judges are susceptible to. They're human, etc. Because Quebec is invoking the notwithstanding clause as a matter of course to all of its laws. Quebec just has that policy. It's part of its whole nationalism, autonomy thing. It's a way that it carves out autonomy from the application of the Canadian Charter. And we know that Chief Justice Wagner is sensitive to the court's perception in Quebec. I should also mention that not only did the Court of First Instance in Quebec refuse to weigh in on the Bill 21's constitutionality, that was upheld unanimously by the Quebec Court of Appeal. And so the court is going to be very wary to rock the boat. That could cause a lot of tension and alienation with Quebec. But on the other hand, in Saskatchewan, this has been a case that has been very socially polarizing, right? This is about trans kids, and counsel for the LGBTQ group, Egal, which has been leading the challenge to the Mo policy, has extensively talked about the potential harms that the policy could cause to transgender youth. It's been very, very emotional in the communications. And Chief Justice Wagner has also called the Supreme Court of Canada the most progressive court in the world. So they could be pulled entirely in the opposite direction. So I certainly hope that these warring impulses will make the court think long and hard about the precedent that they're about to set. And then finally, of course, the elephant in the background of this is our possibly soon to be future Prime Minister, Pierre Poilievre, who's made it very clear that he has no problem with invoking the notwithstanding clause and would be the first Prime Minister to invoke the notwithstanding clause to shield federal laws from review. He's mentioned this in reference to things like the Supreme Court's ruling on cruel and unusual punishment for mass shooters, including Alexandre Bissonnette, the Quebec City mosque shooter. So this is going to have powerful repercussions for how that's going to work. So there's so much to talk about. Josh, you sent us last night a brilliant op-ed that Kobe Kosh wrote this week, where he said this is basically about democracy. He said adding new political conditions to Section 33 would take a constitution that is already difficult to amend by design and would punt it into outer space forever, beyond the reach of all democratic revision. So, Josh, I know that you were really excited about this case. What about it is the most interesting to you, and what are you most worried about?
Yeah, so the moot declarations thing, I'm not as worried about that as some people are. I can see a scenario where courts could, issue more moot declarations, and then the parliament could still say, well, no, too bad, we're using the notwithstanding clause. Maybe that's okay. I'm more worried about them saying there's, some way to get around the notwithstanding clause by using some sort of constitutional principle or some interpretive section of the charter, and that's something that people have been arguing in this case. That actually worries me a lot more. But yeah, Kosh really, it was a great column, and I think one of the points that people have been making, I think Howard Anglin made this point, is that, if courts do the wrong thing here and it harms the legitimacy of the notwithstanding clause and that parliamentary supremacy that it apparently protects, then that might be sort of game over for the Constitution. We'd be in a really rogue place where you can't turn to the Constitution to settle these disputes, and that's not something you would expect in a mature democracy like Canada. It could be really, really bad. I don't know if I'm as nervous as other people about what's going to happen. To have a case heard, there have to be 4 judges out of the 9 that want to hear it, and there might be 4 judges that are just want to hear it because they want to say the Quebec Court of Appeal was right. The precedent from Ford that says, we can't touch this after it's been invoked is correct, and all these other arguments, forget about them. That could be what'll happen here. So for once, I'm not as pessimistic as other people. Christine, what about you?
Okay, so the moot declaration thing, it's a super interesting topic, and I've read a lot about it. I've changed my mind a couple of times about where I land on that. But this is what I will say. I will say if the Supreme Court decides that they can issue moot declarations in a Section 33 case, which is a much more controversial scenario, but they won't issue a moot declaration in our BC vaccine litigation, I'm going to be so angry. That's a much more normal case. You're saying if you can't give declaratory relief under our Constitution, what's the point of the Constitution anyway? Well, that's, I think, what Erica probably thinks right now. What was the point of all of this, to go all of this way only for the court to say, I'm not even going to bother. So if they decide that their discretion, they can exercise it in Section 33 cases, but won't in a Section 15 discrimination case against a child who has a disability, that's crazy. And I can see it happening, and I'm already angry thinking about it. But yeah, that's sort of what I was thinking about today when I was reading the Kassian decision. I'm going to turn now, I'm going to do my bad legal take now, because if we hadn't had this BC case come out, I was going to do a headline about the foreign interference report that just came out. But since I had a headline about something else, I'm just going to give a bad legal take from the foreign interference report. Now, the good news from that report is that it says that there's no evidence to suggest that our institutions have been seriously affected by foreign interference, or that our parliamentarians owe their elections to foreign entities, or there's no evidence that there are, so-called traitors in parliament that are plotting with foreign actors against Canada. The report, that's good. The report said that there is some evidence of attempts of foreign governments to curry favor with parliamentarians, and there have been some concerning conduct by parliamentarians, but not traitor level. One interesting comment from the inquiry was on the INSICOP report that caused a lot of alarm, and the report said that there's a need to better inform the public about intelligence and the limits of intelligence. And this is interesting, because I actually agree that there are problems with INSICOP. That's the National Security and Intelligence Committee of Parliamentarians. And in fact, the Supreme Court has just agreed to hear a case about that particular piece of legislation, and about this question of whether the Prime Minister and Cabinet can unilaterally decide what is a matter of national security and then prohibit parliamentarians from discussing those issues in Parliament with the threat of criminal sanction. So that all relates to the issue of why Pierre Poilievre has declined to get national security clearance so that he can, read the NSICOP report. So we're looking to intervene in that case, and I think that it is related to this issue of better informing the public. And that case, I think, could have the potential of resulting in that. But that's not a bad legal take. I actually agree Canadians need to be better informed. So good, I guess, good take there. The bad legal take relates to disinformation and misinformation, which the report says is the biggest risk to our democracy and is in fact an existential threat. Now, look, I do not want to minimize the problem of disinformation, because I think that it is quite apparent that foreign governments do engage in disinformation campaigns to destabilize our country and seed chaos in our domestic matters. But I do think that there's an issue with defining what disinformation or misinformation is. And this is actually an issue that's been created by the government. No one trusts these terms anymore. And it's because of the way the government has conducted itself, in large part during the pandemic. During the pandemic, we were told all kinds of things were misinformation. We were also told, Joe Biden's cognitive decline is misinformation. It was a deep fake or a cheap fake. He's not really, he's all there cognitively. It's misinformation. We were told that masks did nothing. Don't buy any masks. Then we were told masks were mandatory, and that denying it was misinformation. Now, misinformation is mistaken information. Disinformation is intentionally deceptive or knowingly false information. But these terms now have lost almost all of their meaning because of government. And that's a shame, because these things actually are problems when it comes to foreign interference. So that's the first part of my bad legal take. The second part of my bad legal take is what this report recommends as a response to misinformation and disinformation. It's recommendation number 11 in the report, and it says that the government should consider creating a government entity, so I don't know what that is, like an agency, I guess, to monitor the domestic open source online information environment for misinformation and disinformation, and that this agency could impact how it could impact the Canadian democratic process. The report says that this new entity should have the authority to give and receive intelligence information, and it would do this with national security and intelligence agencies and international partners, as well as civil society organizations. So I assume those are civil society groups approved by the government and probably funded by the government. And the report also recommends giving the entity authority to, quote, interact with social media platforms. And it doesn't explain what interact means. Like, that could also mean a lot of different things. Like, could it require the disclosure of information? Could it, have back entry to social media platform content? We don't know what this means. So this is all explained in further detail in volume 5 of the report. So The commissioner says that this new entity is important because no government agency or body has a mandate to monitor the Canadian online information environment to identify foreign-based disinformation campaigns, and that this is a gap in our democratic institutions. And she stresses that she's not recommending the government monitor all social media activity, I guess just some social media activity, or monitor private or semi-private communications. Now, I have a lot of concerns with this. My big overarching concern is this whole definition of misinformation to disinformation, the idea of what does interact with social media mean, as well as with the potential for mission creep and what this entity would end up doing. Giving authority to a new agency to monitor online behavior and develop intelligence information, I think, is a gateway to collecting information about citizens posting things online that the government doesn't like or disagrees with. You know, there are still people who claim that the Freedom Convoy was a foreign-funded misinformation and disinformation campaign. In fact, one of them is actually running to be the Liberal leader and replace our current prime minister. Mark Carney wrote an op-ed in the Globe and Mail where he said anyone sending money to the convoy should be in no doubt. You are funding sedition. Foreign funders of an insurrection interfered with our domestic affairs from the start. Canadian authorities should take every step within the law to identify and punish them. The involvement of foreign governments and any officials connected to them should be identified, exposed, and addressed. So that's Mark Carney saying that the convoy was a foreign interference operation. And this just wasn't true. You know, 88% of the donations on GoFundMe were from Canadians. Both Give, Send, Go and GoFundMe said there were 0 donations from Russia or China. And you know, at the time, there was this rumor that Russia was funding it. Even CBC claimed that the Kremlin was behind the protest, and they ended up having to issue a clarification. So do we want to empower the government with a new misinformation and disinformation agency? No, I think that's a really bad idea. I think that there are real issues with foreign interference and spreading disinformation. But I have very, very little faith that a new agency to make these determinations will do so in a way that doesn't chill the speech of Canadians and end up surveilling our own domestic protest movements. It gives me immediate concerns. Josh, that was a really long, bad legal take, but I felt like I had to explain it. How about yours, Josh?
Yeah, I mean, I feel like it had to be said, Christine, so I'm glad you took your time. My bad legal take. Wait, I can't even talk. It's been that much of a day. My bad legal take goes to the city of Edmonton, which is a frequent flyer on this podcast. They've had a lot of bad legal takes, and shout out to Lauren Boothby, who's the Edmonton Journal reporter who's always reporting on these things. So they've created yet another new bylaw to regulate bad public behavior, and there's lots of stuff in it that's fine, but and also this version is better than the first version, which would have banned things like using sidewalk chalk. Big priority there. But this still strikes me as way too nanny state, and the big problem is that it bans protests or any gathering without a permit for 100 people or more, so you have to apply for a permit. They're not the only city that has this, but they'll threaten you now with $250 fines if you are at a protest with 100 plus people and you didn't get a permission to do it. And I think this is just ripe for abuse. I think it's a violation of freedom of assembly. I think it's a violation of freedom of speech and of liberty, because you do have the right to roam around in public. And I'm very strongly of the view that you don't need permits to protest. And so we'll add this to our list of worst bylaws, worst censorship bylaws. I can't remember, did we talk about this yet on the podcast, Christine?
I don't think we did. I don't think we did. If you have a bylaw that you think is really bad, we're collecting a list and we're going to give an award. So you can submit it to the ccf.ca/bad bylaws. And we want to, go to that place, that city, and give them an actual trophy for having the worst bylaw. Sorry, go ahead, Josh.
Yeah, no,
Continue.
that's what I was hoping you'd say. So this is my submission for worst bylaws. And the funny thing is, there was a big debate about this, and they originally were going to ban loudspeakers, but then they decided, no, we're not going to ban loudspeakers, but we're just going to require permits for big protests. And I actually think, banning loudspeakers is not necessarily going to be a free speech issue because that's focused on the nuisance rather than the content of the speech. And you could actually deal with a lot of the nuisance here by banning loudspeakers, which have been really obnoxious at certain protests that we need not name, which seems to be the real motivation here. So maybe do that instead of doing things that are clearly not constitutional. The bylaw also bans other dumb things. It bans skateboarding on the sidewalk if you're over the age of 14. Like, why? I don't know. Anyway, so yeah, my submission for worst bylaw. And if you have yours, go to the ccf.ca/bad bylaws and let us know what's happening in your town. Joanna.
Okay, my bad legal take goes to the Père Ambroise Public Library in Montreal, which refused to allow a local writer, Christopher DiRato, to host his book club, to book a room in the library to host his book club. So DiRato is the host of the Violet Hour Book Club, which explores LGBTQ literature, and its members read a mix of French and English language books, but discussions are primarily held in English. And when DiRato sent an email to the library, which is located in the Gay Village in Montreal, which is also incidentally a more French part of Montreal, the library said that the Quebec language law requires the library to program activities mainly held in French. This is also known as Bill 96. And the library said that in order for the Violet Hour Book Club to go ahead, its members had to have all conversations in English must be translated. So they'd have to bring in an outside translator. Now, first of all, this is so out of step with what the culture in Montreal is like. So apparently the books are both in French and English. People speak in both French and English, but it's not only in French. And if you've been to Montreal, you know that like everybody starts a sentence in one language and then like ends it in another language. People are very language fluid in Montreal. But I was happy to read on and see that the province of Quebec and the minister responsible for the French language, Jean-François Robert, says that the library was wrong and that they should have allowed the Violet Hour to go ahead, whether in English or French, or it sounds like whatever the hell language they wanted to speak. He said Bill 96 doesn't apply in this case because the book club was looking for a space to host its activities and was not providing services intended for the public. Therefore, it is not covered by the state's duty of exemplarity, and the charter does not apply. So the library was being a bit trigger happy, misinterpreted the law. I suspect this has to do, again, with the library being in a French part of town. This is what happens when you have bad laws. People are going to interpret them badly. So anyways, I think the law is bad, but especially bad legal take to Father Ambroise, yes, I said it in English, library in Montreal for not allowing a private book club to go ahead in a booked room in a library that all of these people pay for with their tax dollars. And that's it.
Well said. So that's the end of the show. Please do rate us, review us, and subscribe if you haven't already. And you can support our work by going to the CCF's YouTube channel and subscribing to our videos there, hitting like on them, commenting on them, and subscribing. And you can also help out the CCF by signing up for our weekly newsletter, the Freedom Update. The CCF is a nonpartisan legal charity funded by your donations, so please do donate on our website if you can. Thanks for listening.